And well, let's talk about the DPDP rules. The government has finally notified the DPDP rules. The rules include setting up an appointment of core members, including the chairperson. We got in touch with Qasim Rizvi, founding director, The Dialogue, and Dhruv Garg, partner, IGAP, with us to understand more about the DPDP rules. Let's take a look.
This is a very exciting time for all of us, and this is something that is at least 15 years in the making. From the first time DOPT released a paper on as to the approach of privacy, correct? It took a lot of committees, Supreme Court 9-bench judgment, to multiple sort of drafts of the act, and now the rules are released. So at the outset, what does it mean for a general digital Nagrik as we understand, correct? This act and the rules create a set of rights for each and every citizen in this country, or anyone based out of this country, who is interacting with any kind of digital data processing or any kind of entity which is processing the digital data. What does it mean? It means that I have the right, or any of the citizen have the right to know what my data is processed for, correct? I have the right that my consent is taken for the purposes for which the data is processed. I have the right to know exactly what all it is being processed for. I have the right to erase the data when the purpose has ended. I have the right to correct the data if there is any inaccuracy in that data. I have the right for data portability, correct? I can carry my data from one place to another. And I have a right to raise a grievance if any of these rights are not met, correct? First, to the what we call data fiduciary, which is the entity which is processing my data. And if they don't, then obviously I can escalate it to a data protection board as well, correct? So I would say out and out, as more Indians are interacting with the digital world, this set of rights created for protecting their privacy and giving them an autonomy over a set of these rights is the most important thing brought on by the act and the rules, correct? And I think that's a brilliant development. We had seen EU doing it through GDPR. There are the different jurisdictions we're doing it, but now India has entered into that stage where they are giving autonomy to the users over their privacy rights.
Qasim, coming to you then, is India's DPDP Act comparable to global benchmarks like a European Union's GDPR, or is it just a fundamentally different model?
Well, thank you. First of all, I think it's a momentous occasion for all of us to have the first Data Protection Act in India finally notified. To your question, India's act is tailored to the Indian requirements and Indian businesses and Indian people. I think the advantage for us has been that we've been able to learn from some of the mistakes other jurisdictions have made. And we often talk about the Brussels effect. And of course, we've seen the implementation of GDPR over the last few years. And obviously, there are some challenges with respect to how European businesses have now started complaining, and there have been some conversations around the fact that GDPR is a little restrictive. So I think the Indian policymakers, lawmakers have been very pragmatic in the way they have come up with the DPDP Act and now the rules, which is not very prescriptive from the get-go. It allows for businesses to grow, and it allows for the fact that you're looking at the emerging technologies as well. But at the same time, I do want to highlight that, looking at the advent of AI and looking at the advent of how AI systems and models are operating, I think, we also need to understand and maybe look at some of the provisions within the rules and the act itself to be able to say that, okay, is it going to restrict the development and growth of AI in India? And I think with respect to this, one input which I had was the fact that the law doesn't have legitimate interest, and it has only notice and consent as the base for lawful processing, right? Whereas, in other jurisdictions, you might find other lawful processes, a lawful basis for processing as well. So I think maybe there is sometime in the future, the government could consider that, okay, should we need to introduce another lawful basis for processing of data? Do we need to allow for some evolving models? Because if you look at AI, I mean, the models rely on a lot of unstructured, large volumes of data. While you have the exemption for publicly available data made publicly available by the data principal herself, it's very difficult to implement that, because it's very difficult to determine that, okay, who has the made this data available publicly. So there are certain areas which may may require more discussion, but I think the good should not be the enemy of the best, or the best should not be enemy of the good. And I think this is a very important step in the right direction. And I do believe that looking at the way the process has been, it has been a terrific consultation process over the last 8 years, since the time the Puttaswamy judgment came about and the right to privacy was guaranteed as a fundamental right to the people of India. So we hope, and we are pretty sort of convinced that in the future, as the act gets amended and new sort of amendments come through, it'll follow the whole consultation process. And I do believe that with the way technology is moving forward, we'll have to be on our toes and agile with respect to regulatory innovation going forward.
All right, Dhruv, then coming to you, what are the immediate compliance obligations that businesses must meet now that the law is in force?
See, there is enough timeline. So just look at the timeline. There's a concept of consent managers, correct? There is a 1-year time period for that to kick in. There's an 18 months time period for most of the obligations on the data judiciaries and processors to kick in, correct? So there's a 18-month timeline for all of this. But the kind of obligations that will kick in, and as we were discussing earlier, was that they need to figure out and do a gap analysis of all their processes. They have to figure out that on what basis are they processing data. They have to be very unambiguous about the purpose, the itemized types of data that they're asking a user to provide a consent for.